Division 5 of the Colorado Court of Appeals. My name is David Richmond. I will be presiding for the oral arguments today. To my left is Judge Michael Berger. To my right is Judge Casebolt, James Casebolt. He's going to be sitting in for Judge Roman on just the first case, Nieto versus Cherry Creek. So we have two cases on the 130 docket, Nieto versus Cherry Creek and South Park versus City of Englewood. Our counsel for both sets of cases present? I see the people for the first case. Yeah, okay, good. Then I won't have to repeat my directions or instructions again. As I said, we will take a break after the first case to reconstitute the panel. Counsel, you may please be seated. We have 15 minutes per side. The appellant may reserve time for rebuttal. There's a clock on the podium. You can control it yourself. I'm not going to throw yellow flags or anything like that. Please stay close to the microphone because these proceedings are recorded and live streamed. I don't think this applies in either of these cases, but if there is a issue of the concern for the privacy of any of the individuals who might be mentioned, please use initials. If there are no further questions, counsel for appellant in Nieto versus Cherry Creek may proceed.
Thank you. May it please the court. My name is Alan Sweetbaum, and I represent the appellants in this case, Cherry Creek Properties PM LLC, and Constantine, also known as Dino Sarganis. By the way, with me at council table is my associate, Reagan Larkin, who is actually going to be a partner as of January 1, so I'll give her a shout out on live stream TV. You're
not going to divide your time, though.
No, we're not going to divide our time.
You're not giving her too much of a shot on it.
Yes, thank you, Your Honor.
Silent part.
Yes, I was lead counsel of the trial, so I'll do this oral argument. We've obviously raised a lot of issues in our briefs. I'm assuming they've been reviewed by you and your clerks. So I'm not going to deal with all the issues in the briefs. What I want to do is focus my 15 minutes this afternoon on issues related to what we allege and what actually Judge Horton found was Mr. Nieto's spoliation of evidence. If there's time after I finish my argument about that, I think it segues into the two defamation claims that we have asserted as well. Your Honors, in preparing for this argument, which I just indicated I want to focus on spoliation, over the past several days, including, unfortunately, over the Thanksgiving weekend, I became concerned that the timeline of events, which is all on the record, may not have been as clear in our briefs as I think it needs to be in order to really understand why the spoliation issue is so important. So although I understand I've had a lot of oral arguments in the Court of Appeals that you like us less to focus on facts as opposed to law, I just think it's important at least to deal with the timeline.
Mr. Sweetbaum, just so I can put it in perspective, what do you want from us with respect to the spoliation issue?
Well, Judge Horton had entered a written order before he was reassigned, and that order specifically found that there was spoliation. He specifically found that there was intentional destruction of evidence, that it was in bad faith, and that we were prejudiced as a result. So, and then he said, fatefully, that he would, because it was a bench trial, he would enter an order regarding what sanction was appropriate as he got closer to trial. As you all know, 1 week before the trial, Judge Horton was assigned out, Judge Bowles was assigned in, and she basically did not enter any kind of meaningful sanction order. What she did was she allowed my client, Mr. Sarganis, to offer some testimony that would otherwise be considered hearsay, specifically talking about what some of the people who he knew had received these emails and these letters that would otherwise be hearsay. He was able to offer a few minutes of testimony about what they said. That was all she did. We had asked for a continuance of the trial because the defamation claim was only asserted after we found out that all of this evidence was destroyed. She denied the motion to continue. She could have done anything. The court, I don't think there's any question at all, but that Judge Voles, the trial court judge, had the ability to enter a sanctions order. The type of sanctions order is obviously up to the judge and up to the discretion of the judge. However, in this particular case, the conduct was so egregious, was so outrageous, and prejudiced us to such a great extent that I think some kind of additional meaningful sanction order was required. I'm taking a long way to answer your question.
Can
hope
I,
that's
before
okay.
you even answer, let me just clarify, because I didn't understand something you said. You moved to amend the complaint to add defamation claims.
Correct.
When you found out about, I guess, from some of his clients that these emails and communications had been sent?
No, it's not accurate. And that's actually why the timeline was important, but I think I'm going to kind of get into it in responding to your questions. But in fact, what happened was Mr. Sarganis, after the lawsuit was filed, found out that these letters and emails were being sent. As a matter of fact, this one right here, which was a demonstrative exhibit used at the trial, it's evidence, was sent to Mr. I can't walk away from this, was sent to Mr. Sarganis' wife. It's one of what we believe were hundreds, if not thousands, of emails that were sent out. We didn't know where they were coming from. I am answering your question. We didn't know where they were coming from, so we couldn't assert a defamation claim at that time. We couldn't assert a defamation claim until we got the admission by Mr. Nieto that it was he who was sending these out.
Okay, so then you asserted the defamation claim.
Yes.
Then after that, you discovered that the emails were not retrievable.
I think it's actually in reverse order.
You discovered they weren't retrievable, then you asserted the defamation claim anyway.
Well, it sort of all happened about the same time. Mr.
All right.
Nieto admitted in written discovery after refusing to answer, objecting because it was premature, then objecting because of relevance, and then finally admitted that he had sent him. I then took his deposition, asked about these. That in his deposition is when Mr. Nieto acknowledged that it was him and that he had destroyed all record of the emails and that he had only done it 1 week before the deposition was taken.
Okay. And Judge Horton found spoliation and all the things you referred to.
Correct.
When it came to a sanction from Judge Voles, you told us what she did. At the time she made the sanction, or issued the sanction, had she already made some findings about the substantial truth defense that Mr. Nieto was asserting?
No, the substantial truth defense was obviously argued by Mr. Nieto. It was his defense. It was his burden. That finding, that order of the court was not learned by us until after a written order was entered after the trial.
Okay, so she had never said, I think these are substantially true, so a sanction doesn't matter. Nothing to that effect.
As a matter of fact, when I referred, and this was actually used during my opening statements, when I referred to this, Judge Voles specifically made comments about how disturbed she was by this, but then ultimately she determined
Okay.
that it was
Now you better
substantially
answer
true.
Judge Berger's
Yes,
question.
please. What exactly do you want us to, I know what you wanted at trial, which you didn't get, but what do you want us to do precisely?
I think there's a couple of things that you can do. The first thing, excuse me if I can have, there's a couple of things you can do. One of the sanctions order that's certainly permitted by the rules as well as by Colorado case law is to enter a default judgment.
Can we do that?
Well, you can remand and require Judge Voles to do that. And then what she also refused to do was have a hearing on damages. If there is default or default judgment with respect to liability on the defamation claim, we could be remanded to assert a claim, to assert what our damages are. Another option, which I think would be certainly acceptable to us, which is a meaningful sanction order, is to enter what is so often referred to in the case law, which is an adverse inference. Basically conclude, based upon this adverse inference, that the emails, of which we only have a few, we only have 5 or 6. We suspect there are hundreds, maybe thousands of these. Because the only people we know about is the people who came to us, and you would assume that most people aren't going to come to Mr. Sarganis when he's being accused of being a wife beater. So she could, Judge Bowles, whoever the new judge is on remand, could enter an adverse inference that this is defamatory on his face, they have to prove otherwise.
Well, you had a trial on whether it was defamatory, and she found it was true after a full trial. Were you precluded from arguing anything about the truth or falsity of these at the trial?
But just on the ones that we had, the only thing that we could ever argue was based upon the language in the 5 or 6 emails and letters that we had.
Okay, and
We
she
suspect
found,
there were,
and
and
she,
by the way, the language is different. I'm sorry for interrupting. Go ahead.
she found that the documents that were attached to the communications were, and the communications themselves were substantially true. You're suggesting there might be others on which a trier of fact might find they were not substantially true.
That's correct.
But we have no idea, and
That's
you
the
have no
prob-
idea.
But that's the problem. When someone destroys evidence, when someone does it intentionally, when someone does it to conceal their identity and conceal what happened, and they do it after the lawsuit is filed, when they are fully aware of discovery obligations and the rules of the court, they have to pay some type of price. In this case, Mr. Nieto didn't pay any price at all, not even an attorney's fees award. We had to go through a lot of effort and spend a lot of time trying to get to the bottom of who was sending these. We sent a subpoena. Duke has taken to Yahoo. You see the address is convictedcoworkerinfo@yahoo.com. They reported to us that the account was opened up under the name of a woman by the name of Dolores Garcia. When that obviously we couldn't get to the bottom of that, we served a subpoena. Duke has taken them on Comcast to try to find out more about who might be sending these emails. Comcast, because of a federal regulation that they have to abide by, said that you need a protective order. We had to file a motion for protective order. We had to do discovery. We had to file the motion to amend. I mean, there was a lot of attorney's fees and a lot of time spent with respect to this. We didn't even get an attorney's fees award.
Okay, let me ask
Essentially,
you
he
this.
didn't pay a price.
Let me ask you this then. You did have 6 or 7 emails that you did put into evidence, and you argued that they were defamatory.
We did, correct.
Okay. Were those 6 or 7 emails different one from the other?
Yes.
All of them were different one from the other?
No, not all of them. There were differences between, the letters were different. The letters contained a flyer from an organization known as, I think, the National Coalition of Women for Domestic, I may be getting that a little wrong, for domestic violence, suggesting that's who the letter was from, but obviously wasn't. It said something different than this one, which was sent to Mr. Sarganis' wife, which has implicit and explicit threats about not coming forward. I don't even understand what it means to come forward. What would anybody do about that? But if you didn't, you were going to be associated with a wife beater, putting quotes down there at the bottom.
Let me ask one other question about this. I understand that with some of the emails and with some of the actual regular letters sent by snail mail, there was an enclosure containing excerpts from Colorado criminal records of the domestic violence case, right?
That's the crux of it, yes.
That's the crux of it.
Well, I think so.
Were those documents, to the extent you found 6 or 7 of them included in these communications, any different one from the other?
I think those were all substantially the same. However, what was our problem with that is that it was a 20-year-old misdemeanor conviction, and he changed it. He actually what's the word I'm searching for? He modified it.
You allege that you mentioned that in your trial brief, I noticed, but when I looked at the documents, I have to disagree with your conclusion, sir.
Okay.
I think you're looking at 2 different documents.
You think we're looking at different
Yeah,
documents? Okay.
When the documents say plea date, it shows plea of guilty. When the documents show disposition date, it shows dismissed after successful complete. I assume it says completion. Every document is like that. Every one that I found in your exhibit C7 through M7 were like that.
And I apologize because I don't know what you're looking at and I don't have it in front of me, so I
Page
apologize for not
CCP
being able to address that
That's fine, I'll just tell you what
correctly.
it is. It's CCP 001777. That's a criminal record. And it does show plea of guilty. You say in another one that shows plea withdrawn, but I think you're looking at two different dates. On plea withdrawn, it does say that for 10/199, plea of guilty is in there for 10/197. On every document he sent that was attached to these communications that I read.
And you may be right, and I apologize because I cannot specifically address that because I don't have it in front of you. But what I do know is that there were changes, and he had comments
I saw the
to
comments,
them.
yes.
When you're talking about changes, I thought you were talking about those margin comments
That's
where he
part of it,
provided
yes.
this helpful information about defining first-degree assault in one margin comment, and then he characterized it in another as a serious offense. Are you talking about
That's part of it.
those changes, or did he actually purport to change the text of the Colorado printout?
My understanding is that he did change plea withdrawn to plea dismissed. And I could be wrong about that, but that's my recollection, Your Honor.
Actually, what you asserted in your trial brief was that he changed plea withdrawn to plea of guilty, and that's what I was taking issue with.
Yes.
Let's go back to your argument. If we were to enter a default judgment, you would say it should be remanded just for a trial on damages. That hasn't happened, correct?
A trial on damages on defamation has not happened,
Okay.
correct?
And you suggested also that we could approach the sanction by an adverse inference,
Correct.
and the adverse inference would be that these were
That
defamatory,
there were defamatory emails and letters that were sent out.
and that would
Yes.
necessitate a trial on damages
It
then?
would, yes.
Okay. Proceed with whatever you want to do in your next 35 seconds.
I have 31
I'm not going to
seconds.
ask you any
Can-
questions, Mr. Sweet.
Okay. I'm sorry, were you asking a question, Judge
No, no, I
Baseball?
just was saying I'm
Well,
not. I'm gonna
why
give
don't I
you-
reserve 24 seconds for rebuttal?
Thank you, sir.
Thank you.
Please, the court, good afternoon. My name is Clifford Beam, attorney registration 917, and I represent Mr. Nieto. Like Mr. Sweetbaum, in 15 minutes, I don't have a prayer of addressing every issue that was raised in the briefs. I'm prepared to talk about the spoliation issue and the defamation issue. And I would like to know if your honors would have any other specific issue they would want me to address.
Well, why don't you tell us why we should not do what Mr. Sweetbaum wants us to do?
There were these communications that were sent out. And when written discovery was submitted to my client, we first objected to the discovery. But once that issue was resolved, we answered the interrogatories. My client admitted that he had sent them out. And they were all basically essentially the same. They were all advising people of Mr. Sarganis's conviction.
But how can we know that? I mean, if what Mr. Sweetbaum said is correct, that there were a multitude of these communications and we only have 6 of them, how do we know what the others said or didn't say?
I don't think there's any way to know, outside of the fact that they were concerned that Mr. Nieto may have sent these to all of Mr. Sarganis's employees and brokers, and he certainly had the ability to find that out. They only located 5 emails that went out. Sanctions for spoliation is a matter that is ordinarily left to the discretion of the court. The court did fashion a sanction in this case. The question was, how many of these might have gone out? Mr. Sarganis was allowed to testify to the extent he wished about any communications or contacts he had had with anybody that reported that they had gotten these or that he had learned that had been received. The fact of the matter is that every one of these relates to Mr. Sarganis's criminal conviction for a domestic violence assault on his wife. That is the only thing that is covered in any of these emails. It's the only thing that there's any suggestion there might have been any kind of a defamatory mailing. And the law is that whether a communication is defamatory is a question of law. Whether it is truthful is a question of fact. And the court determined that everything that was set forth in these emails or letters was truthful, and therefore there were no damages.
Mr. Beam, this information, the lack of the information was discovered 10 days or so before your client's deposition?
The lack of,
That he had destroyed some of these emails or was unable to retrieve them, let's put it that way.
that was something that we all learned about at my client's deposition.
At the deposition itself,
Yes.
was he questioned at all about any differences in emails as to how many he sent out and to whom he thinks he sent them? Is
Yes.
that information available?
He was asked extensively about that in his deposition.
And to your recollection, and the deposition I don't think is part of the record, was there information gleaned about what differences in the emails there might be?
There were basically two different emails that were sent out. Emails or printed letters, and he was asked about them. Every one of them basically alluded to the assault conviction in the domestic violence case. And there were a number of questions, I think, about the notations he had put on the record indicating that this was a serious offense. He indicated on the record what the penalty was for that offense. He noted that Mr. Sarganis was required to undergo 2 years of probation and domestic violence counseling. And at the trial, based on the certified record of the criminal case, we established that everything on those annotations was factually and legally true. The statements about the nature of the offense, the penalty for the offense, what his sentence was, and what the requirements of his probation were all completely accurate. There were no falsehoods in these communications. They were all truthful, they were all accurate.
Was your position there were no alterations to the text of the criminal record other than the notes he put on the side?
I believe that's true.
Okay. You say there were two versions. You say basically there were two versions of the communications. Mr. Sweetbaum suggests there were 6 or 7 different ones. You disagree with him about that point?
I think they only had, and this is by memory, but I think that they only had 6 or 7 of them, and I think that they basically divided up into 2 groups.
Okay.
There were maybe 3 of one and 4 of the other, but they basically were in 2 separate categories. And the record that was included in those came, I believe, I think this was established at trial, the criminal records came off of a website, Colorado Court's website. And there were, at 2 different times, 2 different versions of the printout of this record, which is why there were 2 different types of reports of the criminal convictions included in these communications.
Mr. Beam, if we don't do something on the spoliation issue, aren't we sending the message to litigants that if there's some bad stuff out there, you're probably better off getting rid of it?
Well, the court did something on spoliation. It was not what Mr. Sweetbaum wanted, but the law is clear that a default judgment is the most serious remedy for spoliation that there is. It is only applicable, according to the cases, in situations where somebody has,
I have to amend my earlier announcement, but I think you all know what I would say.
that was not me, where I'm sorry, I forgot what I was saying.
Sorry, sir.
Oh, spoliation. The case law is clear that spoliation remedies are at the discretion of the court. The theory is that the court is in the best position to judge what has been done and what is necessary to remedy it. The only real question that was presented to the court was the extent of dissemination of these emails, because they were all basically the same. There were differences between them, but they were very minor. And
Well,
they,
excuse me, did Mr. Sweetbaum argue to the trial court that there probably were different substantive emails such that even if these aren't defamatory, the other ones might be?
no, he did not. He argued that they had no way of knowing how many people these emails were sent to. And he said for all they knew, they could have been sent to thousands of people. And the court ultimately ruled that because they were truthful and they were accurate, that it didn't make any difference how many people they went to, because there couldn't be any damages. And there was never any suggestion that there were other types of defamatory communications. There was never any suggestion that anyone had, that Mr. Nieto had sent out anything other than a notification of Mr. Sarganis's conviction for third-degree assault.
Had the judge made a ruling about the substantial truth of the communications before she decided on the sanctions? The same question I asked Mr. Sweetbaum.
She hadn't made a ruling. She didn't make a ruling on that until she entered her final judgment.
After trial.
She did, throughout the trial, give some pretty clear indications that if Mr. Sarganis had been convicted of this offense, then that would be a complete defense to any defamation claim based on these communications.
Yes, but what I'm trying to get at is in trying to decide on the sanction, did the judge at any point take into account or state that what you just argued, which is that it doesn't make any difference how many people it was sent to, it's substantially true? Or is that only a ruling that we find in her post-trial ruling?
She didn't make that ruling until the end of the case.
Okay.
I don't recall that Mr. Sweetbaum had an opportunity to talk about anything but the spoliation and defamation case. And in my 3 minutes left, I'd be happy to address any other issues that the court is concerned about.
Mr. Beam, one of my questions relates to the damages that were assessed in favor of Cherry Creek, the $6,400.
Yes,
Part of your appeal, your cross appeal, is that that was improperly entered.
yes.
And as I understand your theory, it is that there was insufficient proof of the damage?
No, I think the proof was adequate if the court chose to rely on that testimony. My objection to that is that Mr. Sarganis and his bookkeeper/managing broker both testified that there were 6 contracts that had terminated early, 6 or 7 perhaps, and that on those 6 or 7 management contracts that had early terminated, Cherry Creek Realty had the legal right to demand early termination fees under their contract with the property owners that they were managing the property for. They elected not to do that. They made no effort to collect any early termination fees. As a matter of fact, they made a conscious decision to waive those fees. And in the words of Mr. Sarganis, decided they would try to collect them from Mr. Nieto.
So here are my questions related on that. The contract between your client and Cherry Creek essentially said that anybody that came to the firm after Mr. Nieto was employed would be a client of the firm and not of Mr. Nieto's or his other company. Is that right?
That's correct.
Okay. When he signed the referrals that had this reversion clause, was that a breach of his contract?
You know, that's a nice question, because the testimony of Jackie Nieto, who referred those to him, was that if he hadn't agreed to that, she wouldn't have referred those people over to Cherry Creek Realty to begin with.
Okay, but at the time that he signed these referrals, he knew that the contract between Cherry Creek and himself required that any new clients that came in would be Cherry Creek's.
Right.
So when he signed them, he was the employing broker, he had the authority to sign contracts, did he
That's
not?
right.
So he signed the referrals, but that was in breach of his employment contract. So why isn't that, in fact, the measure of damages, the amount of money they could have collected for early termination, but couldn't? Perhaps because the argument was, and you can tell me if this is right or not, that he had authority to bind Cherry Creek. So the referral going back to the other company,
He, those agreements were strictly between Mr. Nieto and the other real estate company. Those agreements were never signed by the clients. They didn't know anything about them. They were not bound by them. They were not part of that agreement.
how does that change the analysis that he breached his contract?
He may have breached his contract by doing that, but I don't think you could show damages, because if he hadn't done that, Cherry Creek Properties would not have gotten those clients to begin with, and they wouldn't have been able to collect the money that they did, up to the point where they terminated. The contracts actually benefited Cherry Creek Properties, because during the term of his tenure there, about 2 years, Cherry Creek Properties was able to manage those properties that came in, and they were able to collect management fees. The contract that Mr. Nieto signed on behalf of Cherry Creek Properties with those property owners did not contain a reversion fee. The property owners had no understanding or knowledge.
Shouldn't it have?
I'm sorry?
Shouldn't it have?
It was not any requirement that was imposed on them. This was just an agreement between two real estate people
But when
about,
the new clients came in, wasn't there an agreement that they would pay a termination fee? Wasn't
yes, there was.
Okay.
And
But
that was,
Mr. Nieto's essentially saying, you're free to come back to my firm, meant that a fee couldn't be collected.
I think legally that that fee could have been collected, and I think Mr. Sarganis made no effort to do that.
Okay, thank you.
Thank you, Counselor. Your time's up.
Thank you.
Yeah. Mr. Sweetbob, since Mr. Beam had an extra approximately 1 minute and 57 seconds, we'll add that to your time. I think it'll take you up to about 2 minutes and 22 seconds. or
I
something of that.
appreciate that, Your Honor. I probably will use all of it.
Okay.
In response to somebody's question about whether or not the deposition transcript was part of the record, it was part of the record. It was used to impeach Mr. Nieto, and the transcript was in fact submitted to the court, and I believe as part of the record. This was another demonstrative that was used at the trial. It is an excerpt of his testimony where Mr. Nieto is admitting that he had destroyed, that he had deleted, he had terminated the email account. And so that he could not get access to it, and we could not get access to it. You'll see he said right here, I formally terminated it last week. In response, I think it was Judge Richmond, you asked the question about the difference between the two records which were attached to some of the emails and to some of the letters, or maybe all of the emails and all of the letters. This is the advantage of having someone sit at counsel table with you who could do the research. I'd like you to compare Defendant's Exhibit B7.
B?
B as in boy 7, with Exhibit G as in George 7. The original record, which came from the internet, specifically makes a reference to status dismissed, and the plea is withdrawn. What Mr. Nieto sent out, again, in the ones that we are aware of, and we aren't aware of all of them, that's, I think, a given here. He actually deleted the status so that there's nothing under the status, and he changed the plea to withdrawn to plea of guilty. So those, in addition to the items in the margin, the notes in the margin, those two alterations, at a minimum, were made by Mr. Nieto. So I hope that clarifies that. With respect to the spoliation order, it was entered after, I'm sorry, do you have a question?
No, keep going.
Okay.
Trying to find B7. I had it here if you
There was a written order that was entered by Judge Horton. It was entered after a hearing. It was a telephone hearing, as most trial judges now like to do to expedite the discovery disputes. And he specifically said he would enter a sanction. The judge did not enter a sanction. And that is, I think, one of the biggest problems that we have. There was no sanction. It's not just not a meaningful sanction. There was no sanction order allowing a couple of minutes of hearsay evidence, what would otherwise be hearsay in a bench trial, where hearsay is certainly can be excluded, but is not that uncommon to see it admitted, is not a sanction for what happened in this particular case. Do I still have time? I
Mr.
can't
Beam
tell. It
said,
zero. Now
I
it
want to
says
give
30.
you a little more time, maybe.
Okay.
I have two questions I want to
Okay.
answer. Mr. Beam said there were basically two versions of these things, 3 of these, 4 of these. Do you agree or disagree with that?
I'm not quite sure what he was referring to. There was letters that were sent out, that was one version. There were some emails that were sent out, that was another version. So there were at least 2 separate versions of communications that were sent out.
But your position, as I understood earlier, that even among the written, the mailed ones, they differed one from the other.
If I said that, I didn't intend to, and I apologize for the misunderstanding. In fact, we know that there are different versions because there's differences in the written, the letters that were sent, and in the emails that
But
were
as
sent.
between the written ones that you recovered, these were essentially all the same.
Well, actually, now that I think about it, I think there was one email that was different than this. I apologize for stepping away from the podium. That email was, I think, specifically intended for Mr. Sarganis' wife. I think another email that we had is different than that. So there are, I believe, 3 separate emails in the record. I mean, 3 separate versions in the record.
Okay.
You said you had a second
Comparing
question?
B7 to G7, which I'm trying to do here,
Okay.
on B7 where it shows plea date 10/1/99, it shows, on B7 it shows plea withdrawn.
It says plea withdrawn, and up above that, there's charged third-degree assault, which is a
Right.
misdemeanor, and underneath that it says status dismissed. In the one that Mr. Nieto sent out, under status, he's whited it out or deleted it in its entirety, and under plea, he wrote plea of guilty. Those are 2 alterations, modifications, which we believe are substantial.
But there was a plea of guilty, wasn't there?
There was a plea of guilty. It was to a misdemeanor. It was a plea. I'm not a criminal lawyer. I think you know that, Judge Berger. But I understand that it still has meaning when you enter a plea of guilty under certain circumstances and then withdraw it later as part of the plea bargain.
But on G7, under that where it shows dispo date 10/1/99, it says dismissed after successful completion.
Which one are you referring to now?
G7.
G7. And I have it in front of me. Where are you referring to?
Below that box where you say deleted status,
Yes.
the next sort of box down says plea date 10/1/97. Below that, it says plea of guilty. You're claiming that he inserted that.
Yes. Because if you look at the original, which is from the online record, it says plea withdrawn under that same line item.
No, but it's a different date.
Well, then maybe-
G7
I don't-
shows
so-
10.
So, and that may go to what Mr. Beam was suggesting.
Yes.
Which was that there may be different versions online. But certainly, when you look at these two exhibits, it appears that he took these and he at least altered the status where he whited it out.
Did he agree to that in his deposition, or did he admit that anywhere in his testimony?
It certainly was, there was cross-examination of him on the witness stand about that. I believe there was also cross-examination in his deposition, and I'm going to be candid with you, Your Honor, I don't remember his response.
Okay, thank you.
I also do want to make one final comment. I realize I'm way beyond time. This issue of spoliation and the deliberate destruction of evidence and the delay in responding to the interrogatories, this has nothing to do with counsel. I have never suggested, I have never thought, I have never believed that counsel was a party to this. I just wanted to make that comment on the record.
Thank you, counsel. Counsel, thank you for your arguments. The case will stand submitted and order will enter in due course. We are going to announce and take a brief recess to reconstitute the panel at this time for the next case, so the court will be in recess for about 5 minutes. Thank you, counsel.
All rise. Court will be in recess.
docket. South Park versus the City of Inglewood. I think all council were here earlier when I made my announcement, so I won't repeat it except to say, if you have an electronic device, cell phone or whatever that might go off during this argument, during these arguments, please turn it off. Off so it doesn't interrupt our proceedings. Counsel for the appellant may proceed.
Thank you, Your Honor. Good afternoon. May it please the court, my name is Timothy Feeney, registration number 41508. I'm with Nathan Dunn Mayor, and I represent the City of Inglewood in this matter. As the court has submitted a written question to be answered at oral argument, I'll respond to that and then hopefully touch on other issues that I believe are important to this appeal. The question submitted to the parties asks, what authority exists that reservoirs should be included or excluded from the definition of public water facility? In response is our position that there is no specific authority addressing whether reservoirs in general are included within the definition. I assert that it is a fact-specific inquiry. In this case, we are bound by the statutory language of the CGIA. As stated in 2410-102, governmental entities may only be liable for their actions in tort as provided under that article. As such, it is improper to review statutes outside of the CGIA to determine whether a governmental entity has liability in tort for a reservoir.
Well, Counselor, let me ask you this, Mr. Feeney. Is it improper to consider the definition of a natural water course? And if not, do you have a definition for it that we could use?
Yes, Your Honor, I do have a definition for a natural water course, and it was cited in our lower court briefing. Water law case, which is City of Thornton v. City of Fort Collins, in which the Supreme Court analyzed a diversion under prevailing water law. The term diversion is reasonable to analyze in this context because it explains what happens when a natural water course is dammed or channelized. In Supreme Court, or in the Thornton v. Fort Collins case, the court found that a diversion which controls water within its natural water course by means of a ditch, canal, flume, or reservoir is an in-stream diversion, hence it's channelized or dammed.
Does it matter if the reservoir was created by man-made excavation as opposed to just simple natural topography once the dam is built?
And again, I believe that that would go to more of a fact-specific issue. I personally have experience with a reservoir that was completely man-made, had everything pumped in. I believe that in that fact-specific inquiry, that reservoir would not fall within this definition. However, we have the lower court's specific finding of fact that is not on appeal in this matter, that this reservoir does in fact dam the natural water course. Now, whether or not that included any excavation in 1965, that also is not in the record.
The record doesn't illuminate at all whether there was any excavation to create this reservoir?
No, Your Honor. It was filled in 1965. It's been in constant operation for more than 50
So
years.
assume, just for the purpose of my question, that it was formed by excavation and the water wouldn't have pooled into the reservoir without the excavation. Where would that leave us? I recognize it's a hypothetical. Where would that leave us?
Your Honor, I believe if there was excavation, any excavation, all that matters is that the dam sits in front of a natural water course. Thus, the natural water course before it and after it is dammed. So whether or not there's excavation, because that allows for channelization or damming. So channelization indicates that there's excavation or rerouting of the water within its natural course. So I believe that an excavation would fit within that as well. Further, this is a natural water course designed for transportation of domestic water supplies, which is also within that exception.
Does the water, in order for the reservoir to be part of the natural waterway, does the water have to continue to flow through the reservoir, from the reservoir into some continuation of a natural waterway?
That's unclear, and I believe that that would also go into a factual determination. In this case, the court determined that it does indeed dam a natural water course. I don't believe that there has to be any outflow. With every reservoir, there doesn't necessarily have outflow, but but we do have a natural water course that runs into a dam, so it's a dammed natural water course.
Well, doesn't that beg the question as to whether that pooling of water behind the dam is a natural water course? It's almost circular. You say because there's a dam and because there's a creek, what happens when the dam is built is just a continuation of the natural water course. Well, maybe it is and maybe it isn't. How do we determine whether it is?
Because we have the facts in this that show that the natural water course is in fact dammed. There's thousands of acre feet of inflow into this reservoir per year. There's a dam placed on a natural water course, and the specific statute states a natural water course, even if dammed, channelized, or used for transporting domestic water supplies, is not included within the waiver. Did that answer your question, Your Honor?
A natural water course is exempt even if it's not dammed, right? That's kind of what this seems to say. Whatever the legislature's purpose was, they seem to exclude natural water courses even if not dammed, right?
Yeah, I'd say an undammed natural water
Right.
course is absolutely.
So a little stream throwing through, there's no liability for somebody drowning,
correct.
whatever it is, okay.
Yes.
Then, what they said is, having excluded that, even if you put a dam there and cause a pool of water, there's still no liability.
You're absolutely, Your Honor.
That's how you would read the statute.
Yes, Your Honor.
Okay.
So, under that reading, there's a lot of reservoirs in Colorado, including some very large ones, almost every one of which is formed in one manner or another by a dam on a natural water course. Is it your position that every one of these reservoirs, I'm thinking about Lake Dillon, there's any number of them, are the operator, if it's a governmental entity, is completely immune from liability for the use of that facility?
In that situation, I would say yes, under a plain reading of the statute, which says if there's a dammed natural water course, and that's how the reservoir, like Dillon, Horsetooth Reservoir, other large reservoirs in the state, if they have a sufficient, or not even sufficient, but if they have natural inflows that dam a natural water course, that they would be exempt under this reading.
And it makes no difference whether the water that is formed by the dam is only a very small percentage of the total water that fills the dam.
Well, Your Honor, I'm not advocating for a governmental entity to fraudulently construct a dam out in the middle of nowhere and make sure that there's a trickle, a seasonal trickle into it. I believe that that would go to a more fact-specific basis. In this one, we have the lower court's ruling indicating that this does indeed dam a natural water course. We have the documents in the case file showing that there are thousands of acre feet flowing into this. What happens when it's 100% of the inflows are related to Dad Clark Reservoir, like it was in December of 2012? Does that, I mean, do we have to do it on a timing basis? This has been operating for 50 years. What if a governmental entity builds a reservoir, doesn't pump any water into it, and then 50 years later says, oh, we can store water there? Does that take it out? I think there's too many hypotheticals that we could go through, that this is a fact-specific inquiry, and the court actually found that this is a dammed natural water course.
Counsel, let me switch gears for a moment. Does it make a difference if the seepage, which is the alleged damages here, comes from a leak in the pipes or through soil in the earthen dam?
Yes, Your Honor, I believe it would.
What difference?
The pipes, well, first of all, pipes were recently addressed in, I don't believe that, let me rephrase this. I don't believe that pipes would be part of the natural water course even if dammed. If it comes from the seepage from the side of the reservoir, as in this, that it's a result of the damming of the natural water course. If it was coming through a pipe that was subsequently leaking, I believe that that would not fall within the dammed natural water course, but it would be actually a physical apparatus that would not be specifically stated within this unless it fits within channelized or used for transportation of domestic water supplies.
I want to make sure I understood what you just said. So we have exactly this reservoir that we have, and now we have an outflow pipe going presumably to a water treatment facility. and there's a leak in the outflow pipe that causes damage to this HOA, you would not be claiming immunity.
In that instance, I don't believe that it would happen. I do not believe that it would fall within this, because as soon as you're taking it out of its natural water course, you're putting it into a pipe, pumping it out of the facility into a different water treatment plant, then you're no longer in a dammed natural water course. You're removing that water and pumping it through a pipe, and it's no longer part of the dammed natural water course.
But the record in this case shows that the seepage came from the pool of the reservoir itself,
That's
not from
correct,
the
Your
pump.
Honor. That's what the allegation is that it's not from the dam, it's not from the pipe, it's actually from the lateral side. Have I responded to Your Honor's
So
question?
through the soil,
Yes.
it's leaking through the soil.
That's the allegation. Now, there appears to be some confusion as to the applicable standard of review to which the HOA is entitled on the notice issue below. The court below, just as the HOA does in appellate briefing, cites to Tidwell in stating that the HOA was entitled to reasonable inferences drawn in favor on the notice issue. However, 109 is a jurisdictional, subsection 109 is a jurisdictional prerequisite to suit. A party seeking to sue a governmental entity in tort must provide sufficient evidence to prove that it provided timely notice. A trial court will not construe those inferences in favor of the plaintiff, and the burden rests on the plaintiff to provide sufficient evidence that jurisdiction exists. While there's tons of evidence in the record that this HOA has been experiencing groundwater problems, recurrent groundwater problems, similar to that of Denver v. Crandall, that they are saying that just the winter of 2012, 2013 is when we got this new issue, hired our expert. In December of 2013, their expert issued an email that said, the issue is, where is the water source? It is not, and that not is capitalized, irrigation, rainfall, or snowmelt. The engineer then cited two possible third-party governmental sources, waterline problems, which would be Denver Water, and the reservoir. They waited another 10 months after that to provide notice, which is improper in this matter. And further, when...
But let me ask you about that. Suppose the engineer in that same email had identified 5 possibilities. Would your argument be the same?
Yes, if they had identified a governmental entity that could be a possible source, because part of the reason why the notice provision exists is to allow the governmental entity to participate in the investigation of the claim, prepare defenses if necessary, or settle it out, or resolve the claim. In this case, the city of Inglewood was deprived that ability by the late notice. They got to perfect their tort claim and then file
So as long as there's a possibility that the party at fault is the government entity, you claim the CGIA requires notice, the notice period to run from that date, regardless of how many different possible actors there may be.
Well, I believe the shotgun-style notice that they provided in here is evidence of that you put notice out to anybody who could possibly be involved, and then they get to figure out whether or not this could be their fault. That's what the notice provision provides. It's a new or should-have-known standard. It's not a tort perfection standard. So they don't get to perfect their tort claim and say, oh, we had to rule out every potential source. And when they had this email in December of 2013 that said, it's one of 2 sources, and then they proceeded not to investigate irrigation. There's no evidence in the file that indicates that they performed any further evidence of irrigation damage investigation. They just singled out this reservoir. So they confirmed his suspicions from December with the report in 2014, and then provided a notice in October of 2014. And we believe that is clearly erroneous, that they provided some evidence of their irrigation.
Well, is it clearly erroneous, or do we review de novo?
I believe you...
What exactly is the standard we use?
Well, I believe you review whether or not the lower court went under the proper standard of review, which is no deference, no inferences in favor of the plaintiff, which would be de novo. I believe that you can find, based on the evidence in the record, that her finding on irrigation, that they have provided some evidence of their irrigation, is clearly erroneous, because there's no evidence in the record that says after December of 2013, they performed any investigation into their irrigation.
Can we do this without there having been a Trinity hearing? Without
Your Honor?
remanding it back?
That's a great question.
That's why I asked it.
In this case, I believe you can. If you don't believe there is sufficient evidence in the record to reverse it, you can most assuredly reverse and remand for a Trinity hearing. We don't believe that that's necessary. We believe that the undisputed facts in this record are actually in our favor, and that the finding, which was made adversely to us, was an improper inference in favor of the plaintiff.
Did you ask for a Trinity hearing? I'm curious.
We did not at the lower level, but in our briefing, we said if you guys think there isn't enough evidence, then feel free to remand for one. And with that, I'll reserve my last 3 seconds.
Thank you, counsel.
May it please the court, I'm Leslie Tuft on behalf of the South Park Homeowners Association Number 2, registration number 34671. I'm going to begin, if you agree, with the timing issue of the association's notice of claim. In this case, Trinity Broadcasting governs the legal standard that applies, and Trinity Broadcasting held that the trial court's factual finding on the jurisdictional issues cannot be disturbed on appeal absent a finding that they were clearly erroneous.
But is that true when there is no evidentiary hearing, as
Well-
there wasn't here?
The Trinity case says that the trial court is the fact finder, and that deference should be given to the trial court's factual findings. And
But why? I mean, the reason that we defer generally to a trial court's findings is the trial court's in a better position. They see the witness, they hear the witness, we read a cold transcript. But if we're just basing the determination on documents, why aren't we in just as good a position as the trial court?
well, because the case law says that the trial court, it's the trial court's province here to be the finder of fact. And the various cases construing Trinity say that in some cases a hearing may be necessary, in some cases it may not be necessary. And in this case, the court determined that it could weigh the evidence based on the record before it. The trial court here made two essential findings of fact. First, that the record evidence shows that the plaintiff did not discover that it had been wrongfully injured by the conduct of another prior to June 2014, and that the plaintiff performed its due diligence by hiring an engineer to help it determine whether the actions of another were what was causing the injury. And the factual record here supports the court's factual findings and shows that they're reasonable. This is a board, an HOA board made up of lay people who are not obviously geotechnical or water engineers. And so they hired an engineer to help them figure out what was going on and where this water was coming from. Early in 2013, they found themselves unable to figure out where this water was coming from, and so they sought the advice of experts. And this is an important fact that shows the state of mind and the reasonable diligence of the HOA. Mr. Masterman's May 2013 proposal, it noted 3 possible sources of where this water was coming from. This is not an exhaustive list, but the proposal noted that there was a sanitary sewer line beneath Mineral Hill and that water was seeping around it. It noted there were other potential water sources such as groundwater or a confined water source, a strata that is controlling the water flow, and it proposed installing monitoring wells and a system to monitor for 6 months to determine the source of the water.
But how do you respond to Englewood's position that once you get it down to a couple possible sources, one of which is the governmental entity, you got to give notice?
Well-
The statute is, neither the statute nor Trinity allows you to sit back and wait and develop proof beyond a reasonable doubt or by a preponderance. You got to give notice when it's boiled down to those couple of actors.
The Trinity case doesn't say that if it's possible that a government actor is responsible for your injury, that's when the notice period starts. The Trinity case very specifically says at page 923 that the notice period is triggered under the GIA when a claimant discovers that he has been wrongfully injured. by another. And that means if there's a possibility that he wasn't wrongfully injured by the tort of another, then the notice period is not triggered. The email that the city refers to that talks about the irrigation, the rainfall, the snow melt, and the water line problems and the reservoir, it's not as clear-cut as the city makes it seem. Masterman responded to a question, what do you think this issue might be, by offering a few lines. One said not irrigation, rainfall, or snowmelt. One said water line problems, question mark, question mark. It doesn't say, as the city implies, Denver water lines, Denver waters, water supply lines. It says water line problems. And that's a general term. Water line isn't a technical term, and it could mean any number of things. He also said right after that, I don't want to say too much until I've done more work. I need to do more work. At this point, he'd asked for 3 more wells to be dug throughout the community, and he had asked for survey data to locate the wells that he had already dug in order to figure out what was going on here. The city interprets that water line problems line to mean it must be Denver water supply lines, but these are lay people. They're not geotechnical engineers, they're not water engineers, and it doesn't say what kind of water lines, and it doesn't say on whose property they might be. Water lines could be any number of things. We know that there is a sanitary sewer line in that hill. The HOA knows it. It could be sewer lines, it could be the community's own water lines. It doesn't have to be a pressurized water supply line owned by Denver Water. Just the receiving that email alone didn't tell the HOA it now needed to go and send a notice of claim to various government entities. It wasn't clear to it that it was a government entity or the tort of another that was responsible for their injury at that point. In the January 2014 HOA meeting, Masterman sought the board approval to place 3 more monitoring wells away from the slope. The monitoring well, one of them was placed near the clubhouse, near the swimming pool, and a couple others throughout the community. And as far as this lay HOA board knows, their expert is trying to figure out what's going on here. He's given them a couple of vague ideas of what he might be thinking, or a preliminary hypothesis of what this might be, but they're relying on him to figure it out, and one of the possibilities contains within it many possibilities that may or may not result from a tort.
So, Ms. Toff, could I have you switch gears at this point? So we're down to 8.5, 8:14. I'm interested in, and I'm going to ask you the same question that I asked your counterpart, Mr. Feeney. What's the definition of a natural water course? And do you agree that Thornton versus a city of Fort Collins includes within that case the definition?
Your Honor, I don't believe that case. I'm trying to think back to the district court briefing now, because this wasn't addressed in the appellate briefing.
Then
But
give me your definition.
Well, I think we have to look at the available authority. And what we do have is the transcripts of the hearings where this natural watercourse language was entered into the CGIA definition of a water facility. And at the record at page 690 is some transcripts from those hearings. And Carolyn White, who assisted in the drafting of the bill, and who Representative Matt Smith asked, he deferred to her testimony about its meaning. She says that she differentiates between a water facility that the government constructs or has control over, and she says there's something that we build, like a dam or a water treatment plant, and she differentiates that between something that is natural. She says the point is to say a natural place where water is running by itself, naturally, that is not man-constructed, is something for which we are not liable, whereas if it's something that we built, then we are. In a separate place in the transcript, she says a water facility is something we built, we have control over it, we can fence it off, we can protect it, and they can protect their liability. In this case, the district court's order, it said that the reservoir does dam a natural water course, but it did not make a factual finding that the reservoir is a natural water course that has been dammed. And I think that is actually an important distinction.
Based upon the topography of this area, would the damming of the creek have created the reservoir without excavation?
I don't believe, Your Honor, that the record reflects whether there was excavation performed. I would say that if there was any discussion of that, it would be in Mr. Brennan's deposition, which is in the record in its entirety, but I don't recall that discussion.
Well, is that important for us to know to decide this case?
I think it could be helpful to know to decide this case, but it's not required. I think that the point is that Dad Clark Gulch, which is a mostly dry gulch that only gets wet when it rains, is only one relatively minor constituent part of the McClellan Reservoir. The reservoir contains many other things besides just this dammed gulch. It's water piped in from Chatfield Reservoir, it's water piped in from Centennial Water District, it's stored for the city of Inglewood, there's a series of pumps and pipes all throughout the reservoir. And so it is not simply Dad Clark Gulch dammed. If it were, then it would be nearly empty most of the time, and it would be far less dangerous. The reservoir is there not because of the water from Dad Clark Gulch, but because there's a depression in the ground, and it was a place to store a lot of other water besides just the water that's coming in from Dad Clark Gulch.
Is there any evidence in the record that would tell us whether, without the pumping in of water from other sources, whether merely the damming of the creek or gulch would create the reservoir as we now know it?
Yes, there is. I don't have the page citation, but some of the exhibits to the summary judgment briefing in the trial court, there is one exhibit that shows the inflows to the McClellan Reservoir and what percentage of the inflows to the reservoir come from Dad Clark Gulch each month over a series of years. The answer brief cites that documentation, and the documentation shows that only 10 to 11% of the water in the reservoir over the course of whatever number of years it is in the documentation that the documentation shows comes from Dad Clark Gulch. The vast majority of the water in that reservoir comes from other places. It's piped and pumped in and stored and collected there
So, Ms.
for
Tuff,
municipal water
Let me ask you
use.
this, and I apologize. So I don't see in the statutory definition where the legislature drew a line based on percentage of water going in from one source or another. It just seems to have the definition of public water facility, and then it has the definition of a natural water cause, among others, as an exclusion. Would you agree with that?
I would agree that it doesn't contain any mentions of percentages, but I would also agree with the city's council that this is probably a fact-specific inquiry. We need to look at whether this reservoir is what the legislature meant when it said a natural water course. And the mere fact that a natural water course is dammed doesn't make it not a natural water course, but the HOA's position is that making it not a natural water course by having many other components as well, with water piped and pumped in from other places and stored there, does make it something other than a natural water course.
And that reminds me of the trial court using the phrase dual purpose, but I didn't see any authority for that. Do you have any authority for a dual purpose?
Well, Your Honor, in the supplemental authority that I filed last week after this court asked the parties to address the additional question of whether the definition of public water facility includes a reservoir, one of the cases is the Daniels case from the Colorado Supreme Court. And that case is analogous. It talks about, I'm trying to find my reference to it. It talks about the primary purpose test in deciding whether the subject of a lawsuit does or does not satisfy the Governmental Immunity Act waiver for public facilities. And it looked at how to determine whether or not something, a particular facility was a public facility, and it said to look at the primary purpose, where a facility serves more than one purpose. In that case, I think the issue was whether a golf course and a parking lot in a golf course was a public recreation facility. And the court found that the primary purpose of the golf course and the parking lot were for recreation, even though the purpose could be parsed out, and there were other purposes of parking lot other than just recreation. So I think that that case is helpful in the sense that it's analogous here, and if we look at the purpose of the reservoir, which all of the record evidence demonstrates is for the storage and collection of municipal water supplies and distribution, and it exceeds the definition of a natural water course. The primary purpose of it is not in dispute, and it's not merely a natural water course, and so therefore that narrow exception to the waiver of immunity does not apply here, and that narrow exception must be narrowly construed as well, because the waiver of immunity is, governmental immunity is in derogation of the common law.
Counselor, your time is up. Thank you for your argument.
Thank you, Your Honor.
I think the appellant has a little bit of time left. I don't know how much. 1 second.
May I please have an additional minute to address?
You can, yes, you may.
Thank you. Specifically with regard to the exception, a dammed natural water course used for transporting domestic water supplies is part of that exception. So this is part of a project that is used for transporting domestic water supplies. That fits within dammed, channelized, or used for transporting domestic water supplies.
Assuming it retains its characteristic of a water course, right?
Correct, Your
It
Honor.
has to be a water course.
A natural water course, even if dammed, which is used for transportation of domestic water supplies.
But
Which is
the reservoir has to be a natural water course. If it's not within the exemption.
That's
right?
correct.
Right?
Yes. As far as the Daniels case, the primary purpose was expressly limited to the issue of whether it's a public recreation facility and inclusive. This exemption from the waiver applies to both structures and related apparatus. So you don't get to say, oh yes, it fits within this exception, let's go back and see if it has another purpose. If that purpose, if this is a structure or related apparatus used in transportation of domestic water supplies, then it still fits within the exception. And I believe that the Trinity case is analogous and the Crandall case is analogous, in that Crandall notes that continuous recurring problems, the notice provision starts at the first problem. With that, I rest, Your Honor.
Thank you, counsel. Counsel, thank you for your arguments. The case will be submitted. An opinion will issue in due course. We are going to move directly on to our 2:30 docket. We have one case on our 2:30 docket, Welsh versus Black and Decker, and as soon as counsel clear the table, counsel for the 2:30 case can move forward. Would everybody in the courtroom please be sure to turn off their electronic devices, cell phones, et cetera? Counsel for appellant, you may proceed.
May it please the court, Robert Lichty on behalf of Samuel Welsh, 14652. This appeal concerns a strategy that backfired. Black & Decker pursued a defense, but it didn't support it. The second sentence of Black & Decker's answer brief sets out Black & Decker's theory that the wound healed and Mr. Welsh had few damages. I quote, "Although Welsh's injury was little more than a scrape and bruise, and although every doctor Welsh consulted found no lasting effect from the sander," goes on, end quote. That is, there was no injury to mitigate. That was the case that Black & Decker presented. A medical mitigation issue would probably require some type of expert testimony. For instance, a failure to wear a night mouth guard would be a failure to mitigate a jaw injury. I got that example out of Lascano versus Vowell.
Are you saying that expert testimony is required to
No.
prove up a
I'm saying
failure
it's
to mitigate defense?
No, I'm saying it's probable when it comes to a medical issue.
Well, I don't know what that means when you say probable.
I'm thinking of, the case I'm thinking of, the Lascano case, and that's 940 P. 2nd 977 at 983, Colorado 1996. In that case, there was medical testimony regarding the use of a night guard, dental night guard is what it was called. And they said that that would, not using that would be a failure to mitigate the jaw
But are
injury.
you saying that in this case, which didn't involve a night guard, medical testimony was required to establish or prove the failure to mitigate defense?
In this particular case, yes, but it was Black & Decker's theory of the case that there was no injury to mitigate.
Well, aren't they entitled to assert inconsistent theories?
Yeah. They can, but then if they don't support the failure to mitigate with any evidence, you're leaving the jury simply to speculate on whether there's any support for that defense. On lost income, Black & Decker presented evidence through its expert that Mr. Welsh did not have the resume or experience to get a musical professorship. Again, this is not mitigation. It is a lack of proving damages in the first instance. This is not a typical mitigation scenario where, for example, you have an injured nurse, she's out for a while, she loses her job, and instead of coming back and getting a nursing position, she takes a position for half the salary in a daycare center. Now, they could argue that's a failure to mitigate. The jury could say, no, it seemed reasonable to us she did that, but at least that would be the typical failure to mitigate argument.
Wasn't there evidence that despite directions from the first-hand doctor that if Mr. Welsh's pain didn't subside, or particularly if it worsened, that Mr. Welsh should follow up with that doctor, and also evidence that he did not do so?
Yes, he didn't like Dr. Solander, so he followed up with a different doctor. Dr.
Much
Solander.
later on, right?
Excuse me?
Much later
No,
on.
no, we're talking about a month later. He went to the doctor in September. He started physical therapy. October 28th, he went until the end of December, so he did physical therapy for 2 months. So, no, to the degree there was a delay, it was a very short delay, and both Dr. Solander and Dr. Klinkscales said, this thing will heal on its own. It doesn't need any treatment. And besides that, at the time that Black & Decker argues that Mr. Welsh should have gone back, there was no reason to go back because it was presumed that this would heal on itself, on its own. So he was giving it time to heal. Then he decided, well, I'll get it long enough time now. I'll go to my doctor, I'll get a prescription for physical therapy, and I'll go that route.
So, Mr. Lichty, when you say then time to heal, so it's not your position, I take it then, that he had no duty to mitigate his damages because of pain in his
No,
wrist?
he would, Every plaintiff has a duty to mitigate.
And that includes pain, right?
Right.
Okay.
Yeah, so every plaintiff has that. And in this case, he said that every morning he would he'd do his exercises for half an hour. Every night he did his exercises for half an hour.
And the jury
He,
heard
he,
that.
he wanted, yes, oh yes.
So-
He wanted to get back to play the piano because he put 25 years into this profession.
But you're saying then that the jury didn't hear any evidence to the contrary,
Correct,
that they put on no evidence
correct,
regarding pain and so.
correct. They're arguing in their brief that Dr. Klingscale said, well, I've treated pain before. They didn't put on any evidence that Dr. Klingscale said with this particular patient, I could have treated the pain with, I don't know, some type of aspirin or something. I'm not sure how he would do it. We don't know. But the jury would have to speculate that it would work in Mr. Welsh's case.
Well, why couldn't the jury draw a reasonable inference that since his pain apparently decreased when he went through the therapy, that if he continued the therapy, it would continue to decrease? Why isn't that a perfectly reasonable inference?
Decreased to what level?
Well, I don't know, just decreased at all.
It decreased. But see, now we're talking about speculation again.
No.
Here are the facts. We know that he went to the physical therapist. He was released by her because it got down to a 1 in 10. He wanted to get to 0. He wanted to be able to play 2 hours. He couldn't do either one of those with her, but she said, oh, you're good enough. I'll let you go. So then a month later, he tries to do the concert at the Balfour Retirement Center, and he can't do it. He gets through with his wife. His wife takes the difficult parts. He takes the easy part, and he had to kind of fudge his way through it. Of course, this is not a judged competition. This is for a retirement community. It's for their entertainment. So they didn't care. But if he wanted to go on to get a professorship, he had to be top notch. He had to have 0 pain, not 1 out of 10, 0. And there's no evidence that he would have gotten to 0 pain. None. The jury could speculate. Now, when you say, couldn't they infer that, what's the difference now between inferring something and speculating? I say that without the evidence upon which to base that inference, it's speculation.
When he went to he saw the second-hand doctor for a thumb injury
Yes,
that he injured during a ski accident.
yes. The other hand, just to be clear.
Is it accurate that during that visit with the second-hand doctor, Mr. Welsh didn't say anything whatever about his wrist?
At that point, there's something in the record about a letter that he actually drafted for his physical therapist, saying that this is what she thought the problem was with his wrist, and she didn't know if it would improve. That letter is in the evidence. So yes, there was some talk about that with her, and it was during that same time period. This is February, not March. I think it was just February of 2017. But in order to have a failure to mitigate, I would like to have the court come up with a definition, because I haven't been able to find one. But I think you must have an opportunity turned down. So an opportunity to medically fix this that he turned down. An opportunity to have a job that he turned down. Again, it's not Mr. Welsh's burden to present that evidence in a failure to mitigate.
Couldn't the
Claim.
jury also, on a different basis of failure to mitigate, couldn't the jury find that by not applying for apparently the number of jobs that most applicants apply for, because these are really competitive positions,
Right.
that itself was a failure to mitigate?
That's what the judge said. That's what the trial court judge said. There's a case, it is Burt v. Beautiful Savior. I didn't cite this in the brief. It says, quote, a
What's
plaintiff.
the name of the case?
Burt v. Beautiful Savior, 809 P. 2nd, 1064 at 1068. And this is what it says. A plaintiff also has no duty to mitigate damages until after the original injury has occurred. And you do get some of these oddball cases where I think that one with the jaw, that night thing
Right,
for the
but
mouth.
he didn't apply for what I'll call the customary number of positions, either before or after.
Yeah, and it doesn't make any difference to the failure to mitigate defense because the evidence that was put on by Black & Decker is he would have never gotten an offer. Again, failure to mitigate is an offer turned down. It was clear from Black & Decker he would have never gotten an offer. Well, how about doing a non-performance job? His specialty was in performance, so if he would never get an offer in performance because his resume wasn't good enough, how could the jury possibly speculate that he would get an offer in an area that he was weaker in?
They couldn't, could they?
No.
So how do you know that the jury didn't give him zero economic damages because they believe that defense?
I don't know.
So how are we supposed to know
We
that?
don't know. That's what Banning and Francis are all about.
But if-
We do know that they found there's a failure to mitigate. We don't know how much the damages were decreased.
But if we don't know that the finding of a failure to mitigate, even if unsupported by the evidence, had no impact on the verdict, why should we reverse this case? You can't show that.
Because of Banning and Francis. In Banning, you don't even, it's not clear at all from the case, written by Judge Casebelt, who was up here the last panel. It's not clear at all from the case that there was even a finding of a failure to mitigate. Because often with the failure to mitigate, it doesn't have to be on the verdict form.
But weren't those cases instructional error cases?
Yeah, both of them were.
But this isn't.
No,
You
but
didn't-
it- but
you
it's-
didn't- You didn't object to the mitigation
No,
instruction.
no, we did not. That was a correctly stated failure to mitigate law.
So I was having a hard time understanding how those cases had anything to do with this case.
Because it's the presumption of prejudice. That's the only reason why those two cases are cited. It's presumed, and we know in this case that the jury actually did find there was a failure to mitigate. We know that. We don't know that in Banning and Francis. There's an indication that they probably made that finding, but it's really unclear from the opinion. But we know in this case that there was a finding, and therefore it's presumed that the damages were decreased. Otherwise, why would you have the finding? Why would the jury make that finding?
Because they were given a question to say, answer this
Yeah,
question.
yeah.
But they could have found zero damages because of what you just said.
It's
There was
possible.
no chance.
I know, it's possible, and it's possible that they didn't, and we don't know.
Well, I'm not sure that we reverse on possibilities, but go ahead with your argument.
No, but it's only possible that they did not. We don't know. Read Banning and Francis. Both of those cases talk about the presumed prejudice.
Do you agree that if we find that there was sufficient evidence to support the finding of failure to mitigate, that it makes no difference that we cannot then determine how the jury applied that finding to reach the damages it reached?
Yes,
Do you
yes.
agree with that?
I agree with that.
Okay.
Yeah, I agree with that. Our only issue on appeal is that there is no evidence, not a little bit of evidence, but there is no evidence of a failure to mitigate on either one of those points, the loss of income and the medical. I'd like to save my remaining minute.
Your Honors, may it please the Court, my name is Alex White, and I represent the appellee, Black & Decker US Inc. in this matter. Your Honors, given my colleague's presentation, I think it makes sense to start here with the standard of review. This Court must view all the evidence in the light most favorable to the verdict and draw every reasonable inference from that evidence in the verdict's favor. And the verdict can be set aside only if, from that very deferential perspective, no reasonable jury could agree with the jury's conclusion here. And while we think there's numerous evidentiary bases for the jury's mitigation finding in the record, I'm going to focus here on the strongest and most straightforward example which is Mr. Welsh's failure to mitigate his pain and suffering. And now, one of the ways the jury could have found that Welsh failed to mitigate was if he failed to seek such medical attention for his wrist as a reasonable person would have sought under the circumstances. And the circumstances here are important because we're talking about a professional pianist allegedly experiencing pain that prevents him from playing the piano. And one of the damages categories that he could have failed to mitigate was his non-economic losses, which the instructions defined as including physical and mental pain and suffering. And indeed, this is the only type of loss for which the jury awarded any damages. So as long as there was evidence showing steps that Mr. Welsh reasonably could have but did not take to reduce his pain and suffering, then the jury's mitigation verdict is supported by the record.
But his theory is that under his particular circumstances, unless his pain were at zero, it didn't, if I have a pain at 1 or 2, I can still do my job. But his claim was that because of his occupation, he couldn't do his job unless his pain level were at 0, and there was no evidence in the record to show that anything these doctors or therapists could do for him could ever reduce it to the 0 level.
That's correct, Your Honor. That was his position, but separately, he had a duty to mitigate his pain. And he sought damages for pain and suffering. The jury awarded him damages for pain and suffering. And even if his wrist couldn't be operated on, there was no physical defect to be fixed, the evidence still showed that his pain could be treated. And this is showed primarily by the fact that his pain was treated. He showed up in October of 2015 at his first physical therapy session, rating his pain as a 5 on a 10-point scale. By his second physical therapy session, that pain was reduced to a 3 out of 10. By his third session, it was a 1 out of 10, and at his fourth session, it continued to be a 1 out of 10. And all this information is available in the record at Exhibit 129 and then at the 926 transcript, much of which is from Mr. Welsh's cross-examination testimony, some of which is from Ms. Martin's testimony.
Was there evidence that his pain could have been reduced to 0 if he had further treatment?
I'm not sure there was, Your Honor, but there was evidence that immediately after he ceased going to physical therapy, his claim was his pain increased and remained constant from that point forward. And the evidence showed that the jury reasonably could have concluded that had he returned to physical therapy, his pain would have again began to decrease gradually as it just had.
Is there evidence in the record that at any time after the incident that he was able to play the piano for hours at a time?
The evidence in the record on that point came from him, Your Honor.
Well, that's
And
still
really-
evidence.
It is, and it's evidence and it relates to his theory of the case, but it really is irrelevant to the question of whether he mitigated his pain and suffering.
No, but did he testify that at some point in time, he was able to play the piano for hours at a time after the accident?
He testified that at the time at which he left his physical therapy sessions, he was conducting his practices again. He equivocated a bit on this point as to how long exactly he could play for, and ultimately I think the record's unclear on that point. But really the question before this court is whether there's any basis in the record to support the jury's mitigation finding, and we think there's ample evidence, particularly with respect to his failure to mitigate his pain. Now, the evidence showed that after he left his PT sessions in December of 2015, both he and his wife testified that his pain increased immediately. And this is the 925 transcript during his wife's testimony and the 926 transcript during his own testimony. The evidence also showed that he never returned or attempted to return to physical therapy after that, and that he never saw another doctor for his left wrist until April of 2017, nearly a year and a half later, when he was examined by Black & Decker as expert witness in connection with this case. And this is despite, excuse me, this is despite the fact that he was seeing the very same hand therapist and the very same hand doctor at the beginning of 2016 for his broken right thumb. Now, Mr. Welsh admitted that he didn't mention his wrist to Dr. Coomer over the course of 4 visits, and that's at the 926 transcript, pages 104 and 171 to 172. And although Mr. Welsh claimed that he told Ms. Martin of his return pain, she testified she had no recollection of this. Her medical records reveal no mention of the left wrist, and she testified she would have sent him back to a hand specialist at that point in time had he mentioned it, which she never did. And this evidence is shown in her treatment records, Exhibit 129, again in her testimony, the 926 transcript, pages 53 to 54, same transcript, pages 65 to 67, and page 71. Now, the jury reasonably could have concluded from all of this that a person in Welsh's position, a professional pianist who can no longer play the piano, would not have delayed seeking treatment and would have followed up as he was instructed to do. The jury could have concluded that had he done so, his pain would have been reduced sooner, and therefore reducing the overall pain and suffering that he allegedly suffered.
Mr. White, could the jury have concluded that that appearing in front of a doctor or a practitioner and not discussing or a pain in the wrist was an opportunity turned down, to borrow your counterpart's definition?
I believe they could have, Your Honor. I believe they could have concluded that in that circumstance, a reasonable person experiencing allegedly increased pain right after the pain had decreased through treatment would have mentioned that to a hand doctor, particularly the same hand doctor that he had been seeing for that previous injury. Now, in the end, really any one of these evidentiary bases is adequate to support the jury's verdict. And it doesn't matter which one or ones that the jury relied on. It also doesn't matter by what amount the jury reduced Mr. Welsh's award. It could have subtracted $100,000 or it could have subtracted $100.
Or nothing.
Or nothing at all. And what matters is there's evidence in the record from which a reasonable jury could agree that Mr. Welsh failed to take reasonable steps to mitigate. And as long as that evidence exists, the verdict should be upheld.
Does it matter? My question to Mr. Lichty is if we can't determine that the jury returned 0 economic damages because of the failure to mitigate, do we have to reverse the case? He says Banning and another case say that. Do you agree with that?
No, Your Honor, and those cases frankly don't say that. In those cases, there was legal instructional error. The court concluded that the jury was misinstructed, inaccurate version of the law, and that therefore had to determine whether it could rule out that legally inaccurate basis as a basis on which the jury mitigated. Here, there's no allegations of an instructional error. There's no instructional error. Here, the question is really whether there's any basis in the record to support the jury's verdict. We don't need to try to get into the jurors' minds. We don't need to conclude what they actually did. The question before this court is just whether there's a basis there.
Was there an argument made that, I take it there was an argument made that this plaintiff would never have received a professional piano contract or gotten accepted to these schools because he didn't have the ability even before his injury occurred?
Yes, Your Honor, that was Black & Decker's theory as to damages.
Okay. And the jury could have believed that and awarded 0 economic damages on that basis.
They could have, and frankly, Your Honor, I believe that's most likely what happened.
But we don't know because we don't have a question that the jury answered that would enlighten us on that, do we?
We don't know for sure. The 0 award of damages for economic losses is a fairly strong indication. But the bottom line is that we don't need to know. The jury checked the mitigation box. They awarded some non-economic losses, and there's evidence to support a reasonable jury concluding that Mr. Welsh failed to mitigate his non-economic losses.
I think you mean his economic losses, but that's okay. Non-economic, okay, his economic losses he failed to mitigate.
He did. He could have failed to mitigate his economic losses,
Yes.
but he also failed to mitigate his non-economic losses and primarily his pain and suffering.
Okay.
You know, my colleague spent a considerable amount of time addressing the evidence concerning Mr. Welsh's failure to mitigate his economic damages, and particularly with respect to his assertion that all of this evidence related to the pre-injury period. And I would just like to point out the evidence in the record that really wasn't the case. While there was certainly evidence that Mr. Welsh failed to take reasonable steps pre-injury, the evidence applied equally to the post-injury period. And namely, that's Mr. Welsh's limited applications. He applied only 3 positions between the time of the incident and the time of trial, and he testified to that in the 927 transcript at pages 44 and 45. And that's as compared to the evidence that showed that his motivated peers seeking college positions applied to as many as 60 to 70 positions per year. The evidence also showed, post-injury, that there was a limited geographic scope in which Mr. Welsh was willing to apply. His wife testified without reference to a time period that Mr. Welsh did not want to apply in the South or on the East Coast, but instead only wanted to apply in the Rocky Mountain in the West Coast region. And that's at the 925 transcript, pages 26 to 29. And Mr. Welsh's applications bear this out. I mean, aside from his alma mater in Ithaca, New York, and I believe one other position in Abu Dhabi, all of his pre-injury applications were in Colorado and California, and that's where his post-injury applications went as well. And this is in the face of his own experts testifying that candidates seeking their first job in academia should and do apply all over. That's Professors Cooperstock and Hagee, who testified on the 27th and the 26th respectively. And he further testified that he wasn't even looking for these college music positions at the time of trial. And that's at the 927 transcript, page 57. I'm happy to answer any additional questions that your honors may have.
Counsel, thank you.
Otherwise, thank you for your time.
Counsel, you have 1 minute and 21 seconds.
Okay. Response to your question, there's no evidence that he ever got to zero pain. There was no evidence that he could ever play for 2 hours. In fact, the evidence was contrary to that. Therefore, when he did not go back to physical therapy, is that an opportunity turned down, Judge Roman? No, because the opportunity has to, in the end, result in a benefit to him. And he went through physical therapy. It didn't work.
So if he was feeling pain, he didn't have an obligation to tell the doctor at that point?
No.
when he went in?
Well, something like that. It doesn't, maybe, but they have to put on evidence that would have made a difference. In order to have a failure to mitigate that's supported by the evidence, defendant has to put on evidence that would have made a difference. Let me read from
But it
Ban.
didn't- The therapy did make a difference. I mean, I understand your theory that
Right.
there's no evidence that showed it would ever get to zero.
Right.
But there was evidence that showed that the therapy reduced his pain from 5 to 1.
Right, and he's not playing at that time. He's not playing at that time. When he goes back to playing, remember, he started playing a month afterwards. He had to start right after the therapy was over. He started playing again, and that's what caused the pain.
Well, I
So
thought-
he could never get it down to an area where he could play long enough.
When I asked that question, I thought I was going off of your definition, which was an opportunity turned down for
Right.
failure to mitigate.
Yeah, but the opportunity has to be able to result in some, for instance, an opportunity of a job. I turned down a job to be a doctor. I'm not a doctor, I'm an attorney. I mean, that's not something that I can turn down.
But if you
So-
have an
so-
opportunity to reduce your pain, isn't that an opportunity turned down if you don't say anything?
Well, he was already doing all of her exercises, in the morning and in the afternoon. He was doing them 30 minutes a day in the morning, 30 minutes a day at night. Can I read the banning, or my time's up? so-
Time's up, counsel. Thank you for your argument. Thanks to both sides of the case for their fine arguments. This case will stand submitted, and opinion will issue in due course. Seeing as we have no further cases on the afternoon docket, the clerk may announce a recess.